What do you understand by citizenship under the Constitution of India? Who are Indian citizens under the Constitution? Ans. What is citizenship? Citizenship connotes certain rights, duties, privileges, and obligations. A citizen of a state is a person who enjoys full civil and political rights, while those who do not have such rights are called aliens. Citizenship means that the citizen shall receive certain care, protection, facilities, be entitled to hold offices, be eligible for recruitment to public services, and be subjected to certain obligations such as taxation, etc. Under the Indian Constitution, certain fundamental rights are available only to citizens. Aliens do not enjoy these rights. The rights exclusively enjoyable by the Indian citizens are enumerated under Articles 15, 16, 19, 29, 30, 58, 1A, 67, 3A, 124, 3 to 17, 2, 157, 165 and 76, 1 of the Constitution. No person who is not a citizen of India has a right to vote for election to the houses of the Parliament and the state legislative assemblies, nor can be he a member thereof. How citizenship is acquired under the Constitution? The Constitution does not contain extensive law on the subject. It lays down certain rules relating to citizenship. These provisions of the Constitution states the classes of persons who are, or who may be deemed to be Indian citizens at the commencement of the Constitution. As regards other things, it provides that Parliament may by law make provisions with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. Pursuant to this constitutional power, Parliament has enacted a special act, the Indian Citizenship Act, 1955. Articles 5 to 8 contain the provisions determining the citizenship of India at the commencement of the Constitution, that is, 26th January 1950. The following are the persons who become citizens of India at the commencement of the Constitution. 1. Citizenship by domicile, Article 5. 2. Citizenship by migrants from Pakistan, Article 6. 3. Citizenship of migrants to Pakistan, Article 7. 4. Citizenship of Indians abroad, Article 8. 1. Citizenship by domicile. According to Article 5, a person is entitled to citizenship by domicile if he fulfills the following two conditions. Firstly, he must, at the commencement of the Constitution, have his domicile in territory of India. Secondly, such person must fulfill any of the three conditions laid down in Article 5. I. He was born in India. 2. Either of his parents was born in India. 3. He must have been ordinarily resident in the territory of India for not less than 5 years immediately before commencement of the Constitution. Domicile is an essential element for determining the citizen of the country. The term domicile has nowhere been defined in the Constitution. In Mohammad Razavi, State of Bombay, AIR 1966 SC 1436, the Supreme Court has held that the term domicile means a permanent house or place where the person concerned resides with the intention of remaining for an indefinite period. In Pradeep Jain v. Union of India, 1984, 3 SCC 654, it was held that the domicile of a person is in that country in which he either has or is deemed by law to have his permanent house. Domicile is of two kinds, i.e. domicile of origin and domicile of choice. The former is acquired by the individual by birth, and the latter is acquired by the individual by residence in a territory with the intention to reside there permanently. Article 5 recognizes only one domicile, i.e. domicile of India. In Abdus Samad v. State of WB, AIR 1973 SC 505 it was observed that to attract Article 5, C of Constitution, person applying must have Indian domicile. Domicile means to the place which a person has fixed as a habitation of himself and his family and not for mere special and temporary purpose, but with the present intention of making it his permanent home. Domicile denotes connection with the territorial system of law. 2. Citizenship of persons who have migrated to India from Pakistan. Notwithstanding anything in Article 5, a person who has migrated to the territory of India from the territory now included in Pakistan shall be deemed to be a citizen of India at the commencement of this constitution if a. He or either of his parents or any of his grandparents was born in India as defined in the Government of India Act 1935 as originally enacted, and b. I. In the case where such person has so migrated before the 19th day of July, 1948, he has been ordinarily resident in the territory of India since the date of his migration, or 2. In the case where such person has so migrated on or after the 19th day of July, 1948, he has been registered as a citizen of India by an officer appointed in that behalf by the Government of the Dominion of India, on an application made by him therefore to such officer before the commencement of this constitution in the form and manner prescribed by that government. Provided that no person shall be so registered unless he has been resident in the territory of India for at least 6 months immediately preceding the date of his application. 3. Citizenship of migrants to Pakistan. Article 7 provides that notwithstanding anything in Articles 5 and 6, a person who has migrated to Pakistan after March 1947 shall not be deemed to be citizen of India. Thus a citizen by domicile under Article 5 and a Pakistani migrant to India under Article 6 ceases to be a citizen of India if he has migrated to Pakistan after March 1947. But a person who has returned to India under a permit for resettlement or permanent return issued by or under the authority of any law is entitled to become citizen of India if he fulfills other conditions necessary for immigrants from Pakistan after July 1948 under Article 6. He can get himself registered as a citizen of India in the form and manner prescribed by the Government of India. In State of MP v. Pierre Mode, AR 1963 SC 645 it was observed that a person shall not deem to be citizen of India is one who has after the first day of March 1947 migrated from the territory of India to territory of Pakistan. It is true that migration after 26th January 1950 would be migration after the first day of March 1947. But it is clear that a person who has migrated after 26th January 1950 cannot fall within the relevant clause because the requirement of the clause is that he must have migrated at the date when the Constitution came into force. Has migrated in the context cannot possibly include cases of persons who would migrate after the commencement of the Constitution. It is thus clear that it is only persons who had migrated prior to the commencement of the Constitution that fall within the scope of Article 7. Article 7 refers to migration which has taken place between the IST day of March 1947 and 26th January 1950. The question about the citizenship of persons migrating after 26 January 1950 will have to be determined under the provisions of Citizenship Act. 4. Citizenship of India abroad. According to Article 8, a person residing outside India shall be deemed to be a citizen of India if he fulfills the following two conditions: I, he or either of his parents or any of his grandparents must have been born in undivided India, and 2. He must have been registered as a citizen of India by the diplomatic or consular representatives of India in the country where he is for the time being residing on an application made to such representative in prescribed form and manner. According to Article 9, no person shall be citizen of India by virtue of Articles 5, 6 and 8 if he has voluntarily acquired the citizenship of a foreign state. In state of UPV, Shah Mode, AR 1969 SC 1234, it was observed that Article 9 deals with cases where citizenship of foreign state has been acquired by Indian citizen prior to Constitution, and means that he cannot claim citizenship of India by virtue of Article 5, 6 or 8.